That's great. Thank you. All right, good afternoon. We will now go on the record. The time is about 1:01 p.m., and this is the time and place for the hearing for Deschutes County file numbers 247-24-000184-CU, another case 185-SP, another case 586-CU, and finally 587-CU. My name is Gregory Frank. I am the assigned hearings officer in this matter. Before we turn to the particulars of this particular hearing, I would like to turn things back over to Mr. Miller, and he is going to describe how this electronic hearing process is going to work. Mr. Miller?
Thank you, Hearings Officer Frank. Good afternoon. For the record, my name is Nathaniel Miller, and I'm an associate planner with the Deschutes County Planning Division. The item before the hearings officer is a proposal for 3 conditional use permits for industrial uses and a site plan review for those uses. Today's hearing will proceed as follows. First, staff will explain the hearing format and how to testify at today's hearing, followed by a brief presentation on the applications. The county has established time limits for testimony as follows. The applicant will have 30 minutes, public agencies will have 10 minutes, the general public will have 3 minutes, and the applicant will be afforded a rebuttal at 10 minutes. The hearings officer can modify or eliminate these time limits. The testimony portion of the hearing will be conducted as follows. The applicant will present first, followed by agencies. Next, persons in support will testify. Then those in opposition will testify. And anyone neutral to the applicant's request will testify last. Afterwards, the applicant will then be afforded an opportunity to present rebuttal testimony. And then finally, staff can make any closing comments. This is a hybrid public hearing with both in-person and remote participation. Before starting your testimony, please provide your first and last name as well as your mailing address. For our in-person participants, if wishing to testify, please add your name to the sign-in sheet. I will use this list to call up participants for their testimony. After your name is called, please come up to one of the tables at the front of the room before beginning your testimony. For our remote participants, if you want to testify, you must be logged into Zoom or have called in using the Zoom dial-in option. When Hearings Officer Frank asks if anyone attending remotely would like to testify, you will need to use the raised hand feature to notify staff. To do this, you need to press the raised hand button on your computer or smart device. Or, if you called in, dial *9. In addition to oral testimony, if anyone has written testimony to submit, please hand it to me directly. If you are in person, please submit your written testimony to me after your testimony. If you are participating remotely, you can submit your written testimony to me via email at nathaniel.miller@deschutes.org. Hearings Officer Frank and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. At this time, I would like to ask if there are any objections to the format of the hearing. If you are attending remotely and have an objection, please use the raised hand function. Seeing none, I will turn it back over to Hearings Officer Frank.
Thank you, Mr. Miller. As Mr. Miller described, we are following the normal hearing procedures in the county code, and I will provide sufficient opportunity for everyone to participate at an appropriate time. I'd ask for your patience as we make sure we get through each of the steps that are outlined. The application is being considered through a quasi-judicial process. I will only consider the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan or land use regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice announcing this hearing there, and they were also set forth in the staff report. The public notice and the staff report are posted on the county's website, and they are also available from staff directly upon request. It is important that you direct all your testimony to the standards and applicable criteria. If you believe that a criterion applies, a rule that should apply was not actually listed. You may address the unlisted approval criterion or that particular rule that you believe is relevant. However, I urge you also to explain why the criterion that you're suggesting must apply, and to do so with specificity so that other participants may respond and so that I can adequately address that issue in my decision. The failure to raise an issue with enough detail to enable me or other participants to respond precludes, in other words, stops you, doesn't allow you the ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue related to any proposed conditions of approval with enough detail to allow me to respond to the issue in my decision precludes, in other words, doesn't allow you to have an action for damages in circuit court. As just noted, I serve as the county hearings officer, and I am assigned to this case. In this role, my job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I'm obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I will state for the record that I do not have any relationship with the applicant, and I'm not aware of any connections that I may have with any other potential participants in this proceeding that would prevent me from remaining impartial. When I say that, I just want to make it clear that I may have had certain participants, based on what I've read in the staff report, who have appeared before me in prior cases. Appearance in prior cases does not render me unable to hear a case. I intend to remain impartial under all circumstances, whether you've ever testified before me or not. I've communicated with staff, but only to discuss the particulars of today's hearing and not the substance of the application. I do not have any ex parte contacts to disclose. It is my obligation to preside over this hearing in an efficient manner. So before we begin, does anyone wish to challenge my ability to objectively hear this matter or to challenge the county's jurisdiction in this matter? Mr. Miller, if you'll let me know if somebody objects.
No hands are being raised. Hearings Officer Frank.
Okay, thank you so much. And finally, I'd just like to, and I'm going to do it ever so briefly, if in fact no one makes a request to keep the record open in this case today, then the record would close today, and I'm obligated to issue a decision within approximately 21 days. If someone does wish to keep the record open beyond the close of the hearing today, you must ask for that to happen. And my request would be that you make such a request or ask at the time you're testifying during the case, so that both Mr. Miller and myself can be prepared to address that request at the end of the hearing. With that, then, I'm going to turn it back to Mr. Miller, and I'd ask that he give the staff presentation or give an overview of the staff report. Mr. Miller.
Thank you, Hearings Officer Frank. The subject property is comprised of tax lot 104 and 201 and is approximately 21.5 acres in size. The property is about 3 miles north of the city of Bend and is along and west of Highway 97. Tumalo Road traverses tax lot 201, and Tumalo Place borders both tax lots on the northern boundary. The entire property is within the rural industrial zone and the landscape management combining zone associated with Highway 97. About the request, as presented in the application materials, the property owner proposes a number of industrial uses on the property. These are identified as a concrete batch and delivery service, 3 contractors' yards, and 2 contractors' yards. As outlined in the application and staff report, the proposed uses are located across the property within different yards. Industrial uses are allowed as outright permitted uses and conditional uses in the district if the applications can meet the criteria for the conditional use permits and applicable standards in a corresponding site plan review. Staff has coordinated with outside agencies and relevant county departments on the proposal. Their comments are included in the staff report. Also, staff received comments from 2 parties in opposition to the proposal. 1 comment was received in support. A few notes about the status of the application. Staff requests the hearings officer to determine if the applications have met the standards of the conditional use and site plan review criteria. These standards are identified throughout the staff report and also in the concluding pages. The proposal and area calculation analysis in the burden of proof appears to be based upon the perfection of the property line adjustment, reference 247-25-000-532-LL. This application was requested not to be included in the hearing proceedings. This is also outlined in the staff report. And then lastly, public comments received which challenge elements of the proposal are also outlined in the staff report. Staff would like to note that all application materials, notices, as well as public agency comments are located on the proposal webpage. This webpage can be accessed through the Community Development Department website and also the web address listed on the screen. As for the staff report, it was sent yesterday to the applicant as well as mailed and published today. The staff report outlines the applicant's proposal, the relevant criteria, and request findings from the hearings officer. Due to the late release of the staff report, staff recommends an open record period to accompany the hearing proceedings. This concludes the summary of the proposal. Staff is available for questions.
Just a clarifying question, Mr. Miller. The last comment on the last slide indicating or referencing the open record period, is staff formally requesting an open record period this time?
We would, in agreement with the applicant, as hearings officer Frank.
Okay, I will certainly ask the applicant if the applicant testifies whether or not they would like to support or initiate such a request. So that's all the questions I have for you. Anything further from the staff?
None at this time. Thank you.
Thank you so much. All right, this is time and place for the applicant to present their testimony. If you're attending remotely, please use the raise hand function. If you're in person, just come on up to the table and make sure you've already signed in. So is there anybody here on behalf of the applicant?
Good afternoon, hearings officer Frank. I don't know if, oh, there we go.
There we go.
Yeah, good afternoon. If you'll bear with me for just a moment, we're going to organize our file materials.
I'll bear with you.
Okay, good afternoon. My name is Tia Lewis. I'm an attorney with Schwabe, and I'm here on behalf of the applicant. And with me is a planner in our office, Daniel Robinson, who helped put the application together. We also have other members of our project team, which are here, and they're not planning on a presentation, but they're available to answer questions should the hearings officer have any. We have Tim Weissup, who is our civil engineer, and Joe Bessman is actually not present, but he is our transportation engineer, and should we need information from him, he will be available to supplement the record.
Okay.
So
before you get started, could you do me a favor and make sure we have your address? And I know it's in the record, but if I don't ask you, then I won't ask everyone else. So your address?
360 Southwest Bond Street, Suite 500, Bend, Oregon, 97702.
And would you ask Mr. Robinson to spell both his first name and last name? Because I can use E's and A's interchangeably, and
yes.
even O's.
Daniel Robinson, Daniel. Last name Robinson, Robinson.
And your address, sir?
360 Southwest Bond Street, Suite 500, Bend, Oregon, 97702.
Sorry for the logistics issues. Go ahead, Mr. Lewis. Ms. Lewis.
No problem. Thank you very much. So I'm going to start with a little bit of history about this piece of property quickly, and then I'll move on to the issues. How can I get to I do have a PowerPoint presentation, so let's see how I can get to it.
I'm patient. There
There we go.
something.
Okay, and then do I use the advance arrow or up?
Correct, just the
Advance, okay. Yeah, let's start with that one. Perfect. Okay. So what I did was I laid the site plan next to the aerial to help put this into perspective for the hearings officer. And I'm going to leave 104 out of this for just a minute. And so I'll circle back to it. But I'm trying not to bring issues into the present application that don't need to be, right? Because there's a lot to address as it is. And so one of the reasons we eliminated the lot line adjustment from the present application was we didn't believe it was necessary in order to be able to decide the application. And I'll tell you why that is in a minute, but I'm going to talk about the history first. So when the client first acquired the subject property back in the 90s, it wasn't bisected by a road. It was 25 acres total, and Tumalo Road was the northern boundary of the property. But in 1998, the county and the applicant and ODOT worked together to create what's known as the Deschutes Junction overpass in this area. And it includes a western approach to the overpass. It includes north and south decel lanes for the overpass. And the highway was widened to 4 lanes. And there's on and off ramps and a roundabout. And the road, Tumalo Road, was created to bisect the property, and there's a tunnel to provide access to both sides of the property. And so, it was really in a different configuration than it is now. And now it's roughly 20 acres. We're talking about just tax lot 201 for the time being. Just tax lot 201 is roughly 20 acres. It started out 25. And so what we created as the subject site for the purposes of this application is shown on our site plan. It is a portion of tax lot 201. And the reason that we did that is because tax lot 201 has a prior land use application that was approved and has since been modified. And it's currently operating as a non-conforming use because it was legally approved under EFU zoning and was been operating continuously since the zoning was changed from EFU to rural industrial. And so we created the site as a 16-acre site. So that is the site plan. It's drawn to scale and it's shown, and it is the everything except for the northwest corner of tax lot 201, and it does not include tax lot 104. And the reason being is that we're approving the uses, we're asking for approval for the uses only in the area that the site plan is drawn. The other uses that are occurring on tax lot 104, as well as the northwest corner of tax lot 201, are addressed in the land use decision that I have referenced there on the site plan that was approved in 97 and then modified again in 99. And I realized as I was putting this up on in our PowerPoint that land use decision is it's in the dial records and it's in a lot of records for the county, but I want to make sure that it's in this record. And so I brought it with me, and I brought not only the 97 decision and the 99 decision, but also the site plan that was approved during both of those, or actually the site plan that was approved in 97. They didn't have one online for the 99 plan, but I brought those to submit into the record, and I'd like to give those to Nathaniel, and those will be made available for the hearings officer's review. I believe that they're important because they describe what is occurring in that area of the property and approve specific uses to occur in that area of the property, very specific, and the applications themselves spell out what's allowed to occur, and it's primarily the sale of hay and farm crops, as well as some specialized farm equipment and hay trailers. And so, again, those are currently operating and have continued to operate as legal non-conforming uses. So we applied for the site plan on a portion of tax lot 201, and given that this is the rural industrial zone with no minimum lot size and more than one use can occur on a site, we believe that drawing the site plan to scale on a portion of a tax lot is an approvable application with the conditional use permits that are falling under that site plan. And so we used the site that we drew on the site plan as a 16.19 acre site to calculate the landscaping requirements. Where staff and we differ in this analysis is that staff has used the entire tax lot 201, which is 20 acres, plus the tax lot 104 as the subject property. And so I think that both staff and the applicant are asking the hearings officer to make a decision on the issue as to whether or not an applicant can apply for a use on a portion of a lot, particularly when the other portion of that lot is already covered by another land use decision. Regardless of which way the hearings officer goes on this situation, this is what I'm saying when I don't believe that it's necessary to take on issues that don't matter. We can meet the lot coverage requirements without any problem. The larger the site gets, the less of the coverage we have, and we already meet the lot coverage requirements. But the landscaping requirements would increase. We currently, if we added in the portion of tax lot 201 that we did not include, we are at like a 12% landscaping requirement, which we're required of 15. If we added in the other 1 plus acre of 104, we'd be a little bit less, but we could still get there. If the whole site had to be calculated for purposes of landscaping, the applicant would be willing to accept that. But it is our opinion that it's not necessary and that a portion of the site can be defined by the site plan that's drawn to scale. So then I'm going to move on talking about the site plan. And one more thing. We did submit the deed establishing tax lot 201 as a legal lot of record. The deed for that piece of property is in the record in our application as Exhibit 2, and it's recorded in volume 154 at page 336, recorded in 1968. So prior to county zoning, it was a legal lot of record. And we also have a lot of record decision. The county recognized it as a legal lot of record in LR 89-148. The client acquired that piece of property by that deed from in 1998. Oh, excuse me. Yeah, actually, the client acquired that. What year is that deed?
The 202.
When the client acquired 201. I believe 1995. Yeah, the client acquired that 201 in 95. 104, though, was a remnant of the reconfiguration of the Deschutes overpass. And so the client didn't acquire 104 until 1998. And that deed describing it is in volume 504-607. Despite the prior county decisions concluding that 104 and 201 had been consolidated, there is no deed records establishing that consolidation. There's a lot line adjustment requesting it and approving it, but the applicant has found no deed history establishing that consolidation. So that's why we've drawn the site plan on a portion of 201 and excluded 104 and left the lot line adjustment application out of this present application, because there's a unraveling of what happened when ODOT transferred the excess land and that sort of thing that doesn't need to muddy the waters for purposes of the present land use application. We will either partition it if it is a part of 201 at some point in the future, or we will establish it as its own legal lot. But for purposes of the present application, we believe the hearings officer can use the site plan we have drawn for the present application. And again, we've established that 201 is a legal lot of record. So as you can see on the site plan, the inner path, the overchange, and the highway forms the eastern boundary of the subject property. And we have several contractors' yards proposed on the subject property, along with access roads and turnarounds. Gonna switch to the next. Okay, so all of the uses, and this was recognized, I believe, in the code enforcement decision that you'll see in the record. The majority of the uses that were occurring when the code enforcement was issued were uses that would have been permitted on the property but didn't have permits. There were a few uses that were on the property that would not be permitted. That was the storage of manufactured homes or old mobile homes, and those have all been removed from the site. We did submit a letter into the record establishing the removal of all of the uses that we aren't currently seeking permits for. So if you look on the property, the uses that we're seeking approval for are outright permitted uses, but we're seeking them under the conditional use permit because of the proximity of dwellings to the subject property. So in the rural industrial zone, most of these uses would be outright permitted, but the proximity of dwellings in this particular location pushes them into the conditional use category. And so on this particular drawing, we've shown where those dwellings are in relationship to the subject property, so the hearings officer can get an understanding of what's going on. So the little black boxes on there with a house inside are the dwellings. And significantly, all of the property owners that own and live in those dwellings have submitted letters in support of the present application, with the exception of the dwelling that is located on the Seventh-day Adventist school property. That's the one that you see in, I don't have a pointer, but it's probably the middle dwelling, I guess, on the western boundary. And that is a manufactured home. It actually just burned. We're assuming that it would more than likely be replaced, but it did burn 2 days ago. Unfortunately, the family that was living in it got out, and everyone was safe. But it is the dwelling that's located on the school property. The other dwellings, Beverly and Harry Fagan, that's the dwelling that's located in the northernmost area. They submitted a letter in support, as did their son, who also lives in close proximity. The other dwellings were the Nolan Wires and Austin Spear dwelling, which is on the southernmost dwelling. And then there is a property owner that doesn't necessarily have a dwelling demonstrated on that drawing, but they also submitted a letter. They own the property on the southwest boundary, and that was Mackenzie Aldridge submitted a letter in support. So in total, despite staff's comments about there only being one letter in support, there are 5. And some of those came in probably after staff prepared the presentation for you today. So they were coming in as we were coming to the meeting. So yeah, so I kind of wanted to give you an idea of what's around here. We did have a video of the client standing on the overpass so that you can kind of understand the level of noise and traffic on this. And we'll submit that into the record so that it can be viewed, but it's not very useful for us to listen to it right now while we're in the hearing. But this is a 4-lane highway, very heavily used. There's never a time, even in the middle of the night, where there's not traffic up and down this road. And the noise from the trucks and the traffic from this road is significant. So this is the rural industrial zone, and I just wanted to give the hearings officer an idea of the location of the rural industrial zone versus the highway. There's also a rural commercial zone right there in the northeast sort of corner of the subject property. And the uses that are occurring in addition to on the surrounding farm and MUA 10 lands, there's some agricultural uses, but on the industrial side, those uses are listed over there on the right-hand column, and there's RV storage and various types of manufacturing and processing uses located in the vicinity. So this will give you an idea of the overall site plan. We do have a site obscuring fence on the northern boundary, and we have one planned along the yard designated as C. I do want to go through quickly, and I have more drawings that will show this site plan in a little bit more detail. The two types of contractors' yards that we've applied for, there's under two different code sections. One is an outright permitted use, and one is a permitted conditionally use. The ones under subsection E, you'll notice, we have two of those. Those are denoted, oops, sorry about that. Those are the ones under subsection E are denoted in blue on our site plan, and those are yards A and C. And then the ones under subsection Q are denoted in red on our site plan, and those are yards B, D, and E. So I can go back to this one really quick and show you that. And that's really, there's not a significant difference between the two yard or the two types, other than the list of uses are just a little bit different. And yard Q does allow manufacturing. However, we have prohibited manufacturing in our yard D in order to mitigate any uses that would occur to the adjacent property owner from yard D. And we have also prohibited on-site sales and services in all of our yards, so that we do not have the public coming to this site for any of the uses that we've proposed in the yards. So this is the portion of the site north of Tumalo Road. This is yards A and B, as well as the concrete batch and delivery service. Again, we have the dimensions of each yard shown on the site plan together with the proposed landscaping. And we also have the dimensions for the concrete batch and delivery service and its location. I can show you, we have a couple pictures of the concrete batch and delivery service and its operational characteristics. And this shows Contractor's Yard A, where they're currently Owens Asphalt is taking place. Owens Asphalt does not conduct any asphalt making or manufacturing on the site. It's the staging area for the trucks and asphalt equipment. Same with Contractor's Yard B. We don't currently have uses in there, but the proposed uses include storage of construction-related equipment and materials associated with farm and forest uses. No on-site sales or services allowed. So then this is a portion of the property south of Tumalo Road. This has Contractor's Yards C, D, and E. Again, we have proposed a site obscuring fence or landscaping along Contractor's Yard C to buffer that proposed yard from the adjacent use. And we've limited the uses in Contractor's Yard D to no manufacturing and no sales and service, on-site sales or service. And these are just, these other ones are just some pictures of Contractor's Yard C, as well as the next one is Contractor's Yard D. In Contractor's Yard D, there are a lot of the storage containers related to the construction services business. And then in Contractor's Yard E, oops, excuse me. sorry. Contractor's Yard E, we currently do not have any uses in that area. However, the proposed use would be for staging area for wildland firefighting trucks and equipment associated with forest uses. So that's the end of the PowerPoint, and I want to briefly touch on a couple of issues raised in the staff report. As Nathaniel indicated, the staff report, we did get it yesterday. I know it wasn't published until today, but he was kind enough to send it to us yesterday, and we had a little bit of opportunity to review it and try to address some of the issues in it, but we will speak with the hearings officer about leaving the record open for a period of time post-hearing to address any of the other issues that we weren't able to get to between yesterday and today, as well as any of the issues that the hearings officer may see as he's going through the materials today. So again, we touched on this briefly. One of the things that we noticed in the staff report was, again, we differ about what we view as the site. And so we did some calculations about landscaping. There's not very many of the approval criteria which would make a large difference as to whether or not the site included all of tax lot 201 plus 104, or whether it only included the portion of set tax lot 201 that we have shown on the site plan. But there are a few, and one of those is the landscaping requirement. The landscaping requirement is 15%, and we are currently at 15% on our proposal. But if all of 201 were included, then we would be at 12, and we would be at a little less than 12 if we added in 104. So again, we can meet the 15% landscaping requirement if the entire 201 and 104 are included together, but we would rather come forward with the proposal as we have proposed it, with using 16.1, I think 16.1 acre, 18 acre area as shown on the drawn site plan. Did you have other issues that we wanted to address?
For contractors.
Okay. Yeah, we I think that one of the other things we wanted to propose, staff had made some findings about site obscuring fencing and or landscaping, and I think that we were going to propose a condition of approval that would try to address that. In some cases, a site obscuring fence, while it would obscure the site if you're driving down the road, might not be the best way to screen the uses on the subject property from adjacent properties, given the difference in elevation and the intervening roadways. And so the applicant has proposed, in some cases, arborvitae or some fast-growing landscaping that might actually screen the property better in the southern area of the site. And so we would like to come forward with some proposed condition language that the hearings officer could consider in order to address the site obscuring matter. And then we do have a 6-foot high concrete fence along, let's see if I can go back to the site plan, along the yard. Is it yard C? Along yard C. Yeah. Yeah.
And then no more than 4 contractors at a time.
Yeah, and then we had limited each contractor's yard to no more than 4 at a time in order to provide a some sort of, use limitation. And we have hours. We were acceptable with the staff recommendation of approval or recommended conditions of approval, including the recommended hours of operation. So I think that was all we had. Like I said, with regard to the issues in the staff report, there are a few items that we would like to address in writing. And I will also submit the analysis of that, of those findings, the prior findings regarding the consolidation of these lots, because we found no evidence that occurred, other than that the county approved an application for it, but never got completed. So we'll submit those in writing just so that the hearings officer has that analysis. And I think that that's all of our presentation for now. I would love to have an opportunity for rebuttal if there are opposition comments. Actually, there's one more thing I wanted to say. We did receive one letter in opposition. There were two opposition letters when the application was first submitted. There was the Seventh-day Adventist Church, and then there was an opposition letter from Central Oregon Land Watch. The Seventh-day Adventist renewed those, and then we revised the application. The Seventh-day Adventist Church did renew those objections, but we did not have renewed objections from Central Oregon Land Watch. They may be here online, they're not in the room, and if so, we'll address them in rebuttal. But for the issues raised by the Seventh-day Adventist Church, we did want to submit the drawings into the record showing the distance of the cement batch plant to the church. It is approximately 700 feet, as well as screened through intervening roadways, some vegetation, a number of structures, and the cement fence. And so we'll submit to Nathaniel that drawing showing the distance measurements for that. I think that's all we have for now, and be happy to answer any questions that the hearings officer has and talk about an open record period.
We are not getting any audio on this side. Hearings officer Frank, is your mic on?
There we go. My apologies. I don't like the feedback that I give from here. Anyway, I apologize. So I do have a couple questions or issues that don't need to be addressed now because there will be an open record period, but I wanted to make sure you understand, all the participants or people involved with this, that I did, in fact, take a couple hours actually to review the staff report, and that's longer than my typical review before a hearing, because I like to be surprised at hearings, sort of. That way, I haven't pre-made any decisions or don't lean any particular direction. I like to be as objective as possible, but in this particular case, as I was going through the staff report, I have a habit of, anytime staff makes a request, that I provide additional findings or clarification findings. I highlight it in some particular color. This one happened to be green, and I noticed as I was getting through this particular staff report, there was a whole lot of green. And so most of them, I think, are fairly straightforward that I have to address, and I think I should be able to reach decisions on those. But a couple of them, quite honestly, since I didn't see this until yesterday, I think I have the potential of being factually confused, at least one of them factually confused. And Ms. Lewis, you certainly attempted. I'm not sure it was a total success. You did a good job. I'm just not sure my success was understanding it related to the lots. So I understand, I think, some of the history, but in the future, which means either in your rebuttal or in your open record submissions, I'd like that particular topic to be as simplified and clarified as at all possible. I think I'm starting to understand that your argument is that the site plan should be the operative physical definitive area. And from what I get from your testimony, the staff has taken a position that it's actually an entire tax lot or tax lots. And that, as you can tell by my last portion of hesitant comments, is I'm not sure I really have that clear. So that is not so much a question to resolve right now, because I think I would probably get more confused. But certainly during your open record submission, clarification on that, and I'd ask staff if they have any additional comments regarding that particular issue, certainly to attempt to educate me so that I actually understand their position and where it's based in code, and what I should be looking at. So that's point one. Point number two that I'd like to make relates to the code violation, which is early on. I think it's in page 15 of the staff report. And I've dealt with this particular issue in a number of other cases, but not maybe this specific iteration of an issue. And that is that it appeared to me, based on the staff report, that staff was saying, hey, all is good. We can consider it. We can consider the code violation in this particular case and the voluntary compliance agreement. Certainly a clarification on that would be helpful, but more importantly to me is, and I, at this stage, I'm always willing to be proven wrong. I don't like it when I issue a decision or an order and then I'm proven wrong because I took the time and effort to make the order or make the decision. But at this point in time, I'm still trying to understand. And in 222015C, the way it appears to me is that that is a definitional section, and it's defining violation. And the way I read it on first blush is that there's a number of ways you can show that a violation is defined in that section occurs. And one of the ways you can show that a violation occurs is through and I'm emphasizing this and putting it in all caps, whatever you want, a signed voluntary compliance agreement. And from what I understand from the applicant is that they're proposing or have proposed a voluntary compliance agreement, which I should then consider and then determine whether or not it in fact is going to satisfy the code violations, at least the way I understand it. I'm not sure that I have the ability to consider a violation an unsigned voluntary compliance agreement. And so, as not necessarily today, but certainly in the open record period, is I'd like both staff and applicant and anyone who is interested to take a look at 222015C and make sure that that we understand exactly what that section is intended to do, and in part, if I'm reading it correctly, which I'll be corrected, that it requires for a violation to have actually occurred, or of the definition of violation to have a signed voluntary compliance agreement. So those are the only two issues that strike me as being somewhat either factually or legally challenging. But I'm certainly going to look forward to having additional discussion on those, both from the applicant, staff, and anyone that's interested. So, Ms. Lewis, if you'd like to take just a couple minutes to respond to what I just said, which is kind of rambling, apologize. You certainly have the right to do that.
I would be happy to, and I will respond in writing as well. But with respect to just subsection C, the other way that you can determine a violation has occurred is a prior county decision determining that a violation has occurred. And that's what we have in this case. We have a code enforcement order, which currently has fines being assessed daily on this property. So under subsection C, we do have an order determining what the scope and extent of the violation is. And we have submitted evidence into the record establishing that we have removed all of the items that were identified in that order, but for the ones we are currently seeking land use approval for. Because there were a few that are identified in that order that weren't approvable, right? So not the only way to to address code enforcement is either to stop doing what they cited you for or to get a permit. And so we stopped doing what wasn't permittable, and we're seeking a permit for what is. I do recognize, though, that we did submit an unsigned voluntary compliance agreement. And the reason for that is because we wanted to make sure that the scope of that compliance agreement was based on what the hearings officer was approved through the land use decision. And then anything that's not approved through the land use decision, we have agreed to remove under the voluntary compliance agreement. Again, we've already removed what the code enforcement order spelled out as being out of compliance. Yeah. And so, I mean, we could submit the voluntary compliance agreement into the record as a signed document, but our goal in that, in submitting it unsigned, was to continue to work with the county once the land use decision, this land use decision, was approved, because our compliance is twofold. Our compliance is seek permit approval and remove anything that is not permittable. But again, I will address this in a little bit more detail in writing.
Okay, and with that, and once again, I'm still at the initial stages of trying to understand this. My guess is you've probably looked at this case more than one day. Looks like it has quite a history. I've now looked at it about 24 hours. And so if it sounds like I don't have a firm grasp on either the facts or the legal aspects of it, that's because that's where I should be at this point, in my opinion. So I guess sort of as a follow-up question, and this is also relevant to anything staff may wish, is that rather than the VCA being signed or unsigned or whatever, it appears to me that the purpose of this whole section of the code is to allow us to deal with code violations effectively and efficiently in the land use process. Obviously, I'm not a code hearings officer for Deschutes County. Code hearings officer made a decision in this case based on all the due process, all the requirements of those provisions. What I'm looking at, if the goal is in fact to adequately address in the land use process the code violations as set out and found by the code hearings officer, perhaps it's all semantics, but perhaps it's just a condition rather than a voluntary compliance agreement. And I guess that's where I was kind of heading from the start, is that you effectively addressed my C section of the code. I like that, so I'm buying that argument, at least at this point, unless I hear something to the contrary. But in order to satisfy the overall goal of 22-2015 is we might want to look at a different vehicle, a legal vehicle, maybe a condition or something. So with that, anything else before I turn it over to supporters?
No, thank you. We accept, we are acceptable of a condition of approval, and we'll again follow up with you in writing on how that might strategically work.
And I'd appreciate it if you followed up with staff on that as well, is that I believe both sides of that equation can result in something acceptable potentially to me. So with that, is there anyone here who would like to testify in favor of this application? And that includes those of you who are in person, or anyone who is listening, would like to participate online. Mr. Miller?
We have no participants online and nobody in the building as well.
Okay, so this would be the time and the place to ask for opposition testimony. And that includes anyone in person, anyone online, however you see or hear this. If you can raise your hand or come up and participate, that'd be appreciated.
There is also no one online or in the building. Hearings
Well,
Officer Frank.
thank you. I have a feeling the very same thing is going to happen because it's happened in every case that I've done in Deschutes County. I'm asking for any neutral participants.
And lastly, no one online or in the building. Hearings Officer Frank.
Okay. So with that, then I'm going to give Miss Lewis rebuttal, which certainly right after your testimony. So it seems a little. The only thing you might want to address here is is my initial question about the open record period, or so from the perspective of, do we stop the clock, start the clock, ignore the clock, whatever you want to call it? Is it the request of the applicant to keep the record open?
Yes, we've spoken with staff about this, and we would ask that the record remain open for the first initial period of 14 days to allow us to address the issues raised in the staff report and submit any evidence during that first 14-day period so that anyone, including the applicant, could submit evidence.
Cool. So what you're telling me is, instead of a 7-7-7 kind of approach, we're taking a 14-7-7 approach.
Yes, that'd be preferable, just due to the Thanksgiving holiday on the first. It would fall for 7 days.
I appreciate your recognition of that. All right. So with that, then, anything else from the applicant?
No, sir.
Okay, this is time and place for the staff. Any final comments from the staff?
Just one. We're happy to follow up with a memo to the record just addressing that section on 22-20-015. So we will be including a memo to the record on that in staff's position. Also, if there are no other issues to cover, Hearings Officer Frank, staff would also like to just cover the open record period and the some information to help people submit comments if necessary.
That would be great. Let's consider it, instead of the 7-7-7, let's consider a 14-7-7. And if you can give us comments about confirming that is acceptable to staff, and then the logistics of getting information into the record during those periods of time.
Okay, thank you, Hearings Officer Frank. So as outlined, a 14-7-7, you'll see on your screen there the dates and the time periods at which those phases will close. So new evidence and testimony will conclude on Thursday, December 4th at 4 p.m. The rebuttal phase will conclude on Thursday, December 11th at 4 p.m. And then finally, the final legal argument. This is applicant only, will conclude on Thursday, December 18th at 4 p.m. Just some notes about the open record period. Please keep in mind that all submittals should be addressed to me. For email submittals, please use my email, which is nathaniel.miller@deschutes.org. The county does not retrieve information from a website link or personal cloud storage device. It is your responsibility to submit all evidence and testimony you want the hearings officer to consider. And then lastly, any electronic submittals must be received by the county server by 4 p.m. So please do not wait until the last minute to submit your evidence and testimony. And this concludes the instructions. Thank you, Hearings Officer Frank.
Thank you, Mr. Miller. And I'm just going to repeat, and I know it's probably not necessary because you did a great job, but I'd like to emphasize this: December 4th at 4 p.m. Anyone who wishes to submit new evidence may do so. And you're going to do so in conformance with Mr. Miller's instructions. Information is kind of like, your sixth grade teacher. Anything that comes in after those period of time or doesn't follow the instructions is not going to be considered. It's late. I won't look at it. All right. So December 4th, new evidence, 4 p.m. December 11th at 4 p.m., you're allowed to provide rebuttal evidence or evidence in rebuttal to what was submitted. And that is also at 4 p.m. And then finally, Ms. Lewis, only you and the applicant have the right on December 18th prior to 4 p.m. to submit a legal rebuttal. I caution this in every case. Ms. Lewis, you don't really need it, I guess. But if there's any new argument, new evidence included in the final rebuttal, then I tend to not consider it seriously or at all. And so I know you're experienced enough, you don't need that, but I'd like to put it in the record, irrespective of the face that I'm looking at on the screen. So with that, any further questions, comments, or concerns, Ms. Lewis?
No.
Anything further from staff?
Staff has no further comments.
All right, I appreciate everyone's presentations in this case. Everybody's very respectful, and that is always appreciated. Even when I ramble and ask silly questions, you didn't make me feel like I rambled or asked a silly question. So that is very much appreciated. I look forward to any written response, particularly to the issues that I raised following the applicant's presentation. With that, then, we will close the hearing. Look forward to receiving the information in the open record period. I will issue a decision within 21 days of the record closing. Final comment, Ms. Lewis, I tend not to like to close the record early, but if you did want it closed early, keep in mind it's a request, not a demand. It's not a mandate. So if you do wish to request the record to close open so you can get a decision earlier, maybe by a day or two, please make that request, and you have every right to do so. All right, with that, we'll close the record. Thank you.
Thank you very much.